Good morning, everybody. I'm Attorney Majel Shaby Guzman. I am your lecturer for Criminal Law Book 1. Our topic for today is Article 3 of the Revised Penal Code. Okay, Article 3 of the Revised Penal Code, which means that we will be discussing the elements of a crime in general, the elements of felonies. Okay, Dolo versus Culpa, or intentional felonies versus culpable felonies, mala inse versus mala prohibita, and also Actus Reus, mens reus, and Voluntariness, which are the elements of a crime in general. Aside from that, we will be defining important terms such as the crimes, felonies, offenses, misdemeanor, and infraction. Okay, so before we start, kindly get your codals to those who have their own codals or the printed version of the Revised Penal Code. And go to Title 1, Chapter 1, Article 3 of the Revised Penal Code. Okay? Sabay-sabay nating basahin mga kapatid. Okay. Article 3, Definitions. Okay? Acts and omissions punishable by law are felonies or delitos. Felonies are committed not only by means of deceit or dolo, but also by means of fault or culpa. There is deceit when the act is performed with deliberate intent, and there is fault when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. Okay, so that is Article 3 of the Revised Penal Code. Before we discuss these felonies, this dolo or culpa, let's first define. When we speak of crimes, this is the general term which pertains to the act or omission in violation of any penal law forbidding or commanding it under pain of penalty. So yung crimes, ito yung generic term for acts or omissions na pwede kang maging criminally liable. Okay, crimes. Under these crimes, there are two types. There are several classifications. We have offenses, which is a crime punished under a special law. Pag sinabing offenses, ito yung mga krimen na pinapunish or nasa ilalim ng isang special penal law. Okay. Pag sinabi natin na felony, when we speak of felony, these are the crimes punished under the Revised Penal Code. Okay? So we have crimes, we have offenses, which are punishable by special penal laws. We have felonies, which are punished by the Revised Penal Code. Anong example ng felony? Murder. Okay, murder is a felony. Okay? What else? Estafa under Article 315. Okay, that is a felony because it is found under the Revised Penal Code. What is an example of an offense? Okay. Violation of RA 9262. Okay, that is an offense because it is covered by a special penal law, which is Republic Act 9262. Okay, so those are the difference between an offense and a felony. Ano pa ba yung parating ginagamit? We also have an infraction, which is used, kapag sinabi namang infraction, usually it pertains to an ordinance. Okay, ordinance created or enacted by your sanggunians. Okay, we have a municipal ordinance, barangay ordinance. Okay, what else? Misdemeanor. Misdemeanor refers to minor infractions, but this is not used within the Philippine jurisdiction. Okay, so those are important terms. Now we go to the elements of crime in general. Okay, there are three elements of a crime. So, crime muna tayo, yung generic term ng acts or omission. We have the Actus Reus, the mens reus, and voluntariness. Okay? Again, Actus Reus, mens reus, and voluntariness. Say Actus Reus, it is actually the physical aspect consisting of an overt physical activity, which is capable of producing the act into the outside world. Okay, they include overt physical positive acts, omissions, or oral declarations. In short, pag Actus Reus, this refers to the criminal act. You do something or you do not do something which is criminal in nature. Okay. When we speak of mens rea, This refers to the mental component of a crime. Okay? It is the state of mind required in order that a person will be criminally liable. So, pag mens rea, ito yung criminal mind. Actus reus is the criminal act. Mens reus is the criminal mind. Okay. How are we going to understand that? Gawa tayo ng scenario ulit. Nilgar and Merle are married. They are happily married. Paulo is in love with Merle. Okay. Magandang example. Okay. Dahil si Paulo ay in love siya kay Merle, sabi ni Paulo, patayin ko kaya to si Nilgar para maligawan ko si Merle. Okay. Patayin ko kaya to si Nilgar para maligawan ko si Merle. Okay. That is the mens rea. Yung nasa utak ni Paulo ay isang criminal mind. Correct? Patayin. Ang pagpatay ay isang act or omission punishable under the revised penal code for homicide or murder. Correct? Meaning, there is criminal mind. There is mens rea. Now, is Paulo already criminally liable for a felony? Naisip niyo yun, sa utak niya. Yes or no? Not yet. Okay. Paulo is not yet criminally liable because the law requires that there is also actus reus, that he act upon the criminal mind. So, paano kapag ang nangyayari ganito? Sabi ni Paulo, patayin ko kaya ito si Nilgar para mapasa akin si Merle. Okay. Tapos, kinaumagahan, bumili siya ng lason. Pumunta siya sa mall, bumili siya ng lason. There's a criminal act. There is also a criminal mind, which is ang pagpatay kay Nilgar, and there is a criminal act, which is pagbili ng lason. Okay, there's an act already. Is Paulo already criminally liable for a felony? Yes or no? May actus reus. In that example, meron na tayong criminal mind, meron pa tayong criminal act. Is Paulo already criminally liable? Under the law, Paulo is not yet criminally liable. Why? Because the act of buying poison is not considered an overt act of murder or homicide, as the case may be. When we speak of actus reus, the law pertains to the act, which is an element of a crime already. Okay. It does not pertain to preparatory acts. Okay. When we say preparatory acts, these are acts which may or may not lead to the commission of a crime. The act of buying poison. Halimbawa, si Paulo, bumili siya ng moriatic. Okay. That is not a crime. Okay. That is not an overt act of murder. Ano pa? The act of buying a gun. The act of buying a knife. Okay. Those are mere preparatory acts. Okay. And the actor is not yet criminally liable. Okay? What if ang ginawa ni Paulo ganito? Sabi niya, patayin ko nga si Nilgar. Tapos bumili siya ng muriatic acid. Okay. Tapos yung muriatic acid, hinalo niya sa inumin ni Nilgar. In that case, is Paulo criminally liable for a felony? The answer would be in the affirmative, yes. Because Paulo has already entered the stage of an attempted commission of a crime. The act of putting the poison in the drink, yung iniinom ni Nilgar, is already an overt act of murder. Okay? So, liable na siya dahil yung kinumit niya na act is already an overt act of murder. Napas niya na yung sinasabi nating subjective phase. Okay. We will be discussing the stages of execution later on. Yan yung attempted, frustrated, and consummated. Okay. But for now, okay, yun lang yung kailangan natin. Okay. Dapat yung overt act would logically result to the commission of the crime. Okay? Nung hinalo niya doon, ang ibig sabihin, makikita mo na yung intent niya to kill, okay, the person. Okay? Unlike kapag bumili lang siya ng baril o bumili lang siya ng poison, malay mo ba kung saan niya gagamitin? Correct? Pero the moment na nilagay niya doon sa inuming nilgar, alam mo na na mayroon siyang intent to kill. Okay, so that is Actus Reus and Mens Reus. Now we go to the element of voluntariness, which is the third element of a crime in general. Okay, voluntariness. When we say voluntariness, this pertains to the fact that the act or omission must be the result of the conscious choice and deliberate will of the accused. Okay. Dapat conscious choice and deliberate will of the accused. There must be freedom of action, intelligence, and intent. Okay. Yun ang voluntariness. Okay. Gawa tayo ulit ng scenario. Okay. So, yung scenario natin kanina, si Paulo, okay. Of course, voluntary na ginawa niya yun. Wala namang pumilit sa kanya. Okay. So, very clear naman sa facts. Pero gawa tayo ng medyo complicated. For us to understand the concept of voluntariness, Actus Reus and Mens Reus, okay, let's make a more complicated scenario. For example, ako, okay, si Attorney Shay, okay, broken-hearted ako. Okay. Dahil broken-hearted ako, okay, sabi ko, gusto ko na magpakamatay. Okay. So, pumunta ako sa rooftop ng isang building, tapos magsusuicide ako. Nasa rooftop na ako, tumalon ako. Okay. Tumalon ako, pakamatay na ako. Okay. Pagkatalon ko dun sa building, okay, sumabit ako. Okay. Sumabit ako sa isang tent, sabihin na natin, or canopy. Dahil doon, hindi tuloy-tuloy yung pagbagsak ko. Okay. Pagkasabit ko sa canopy, okay, less na yung impact, tinamaan ko si Makmak. Okay. So, pabagsak ako. Tapos, tumama ako sa canopy. Nabawasan yung impact. Tumama ako kay Makmak. Si Makmak, napilay. Okay. He suffered physical injuries. Okay. Now, what is my criminal liability as to the injuries suffered by Makmak? Am I criminally liable for the injuries suffered by Makmak? Okay. Let's first determine whether or not there is mens rea, actus rea, and voluntariness. Okay. Number 1. Is there mens rea? Nung sinabi ko sa utak ko na magpapakamatay ako, is that mens rea? No. No. The act of committing suicide is not a crime. It is not punished by the revised penal code or by any special laws. Okay. The act of committing suicide is not a crime. Okay. The act of ending your own life is not a crime. Okay. Ang pinapunish ng batas ay yung giving assistance to suicide under Article 253 of the revised penal code. Meaning, nung tumalon ako sa building, I was not committing a crime. Okay. Wala akong mens rea, wala mens reus, wala rin akong actus reus. Correct? So, wala yung dalawang element. Okay. Question number 2. Okay. When I injured Makmak, is it my deliberate intention? Okay. Nung tumalon ako, ang intention ko ba ay tamaan at saktan si Makmak? Yes or no? Of course, no. My intent was to kill myself. okay, was to end my own life. Okay. Therefore, there is no voluntariness of the act that injured Makmak. Okay. Therefore, I was not criminally liable. Okay? Hindi ako criminally liable for the act or for the injuries suffered by Makmak. Okay? The answer would be different kapag ganito. Dahil broken-hearted ako, gusto ko nang magpakamatay. Sabi ko kay Manuel, Manuel, gusto ko nang mamatay. Ito yung barel. Barilin mo ko sa ulo. Okay. Dahil best friend ko si Manuel, sabi niya, kung yan ang kagustuhan mo, attorney, okay, gagawin ko. Okay. So, kinuha ni Manuel yung baril, tinutok niya sa ulo ko, pinaputok niya. Okay. Kaya lang, dahil kinakabahan si Manuel, nanginginig yung kanyang kamay, nung pinaputok niya yung baril, hindi ako tinamaan. Ang tinamaan ay si Arnel. Okay. Si Arnel na nanonood sa kabilang kwarto. Okay. In that case, what are the criminal liabilities of attorney? Okay. Kung anong criminal liability ko? What are the criminal liabilities of Manuel?
As far as I'm concerned, I am not liable for any crime. Okay, same reasons as the previous scenario. As for Manuel, Manuel is liable for giving assistance to suicide under Article 253. Okay, as to his acts towards me in helping me commit suicide, and he is likewise liable for physical injuries as to the injuries suffered by Arnel. Okay? So, those are the elements of a crime in general. We now move on to the elements of felonies in general, which are provided under Article 3 of the Revised Penal Code. Element number 1, there must be an act or omission. Okay? Same as the previous discussion, there must be an act or omission which is punishable by law. This should pertain to overt acts and not only to preparatory acts. Element number 2, there must be an act or omission punishable by the Revised Penal Code or by the law. This is exemplified on the Latin maxim, nullum crimen, nullum pena sine lege. Okay. Nullum crimen, nullum pena sine lege, or there's no law, or there's no crime if there's no law punishing it. Again, there's no crime if there's no law punishing it. Okay. And the third element is that the act is performed or the omission is acquired by means of dolo or culpa. We first discuss, okay, the second element, nullum crimen, nullum pena sine lege. Paano ba natin ito i-discuss? Remember the love bug virus. Ay, alam niyo to. Sometime on the early 2000s, there was a computer virus which proliferated in the cyberspace. Yun yung message na I love you love letter. Okay, sent to many persons in the internet. Once you opened that message, okay, it will gather your stored personal information in your computer like credit card passwords, PIN codes, personal information, etc. That virus caused several damage to the cyberspace, not only here in the Philippines but also in abroad. Okay. After some time, the US, okay, other jurisdictions were able to trace that virus here in the Philippines. That in fact, it was created by an AMA computer student for his thesis. Upon arrest of that AMA computer student, he was prosecuted for theft. Why theft? At the time of the commission of the act of creating a virus, there is still no cybercrime laws enacted here in the Philippines. There is still no e-commerce law. Kaya, hindi pwedeng i-prosecute yung AMA computer student ng violation of Cybercrime Prevention Act or ng e-commerce law. Because at the time of the commission of those act, wala pang batas prohibiting the act of creating a virus. So, ang na-file lang sa kanya ay theft, which was then dismissed due to lack of evidence. Na-dismiss lang din yung case na yun. Okay. So, yun yung example ng nullum crimen, nullum pena sine lege. Wala pang crime, prohibiting the act. Therefore, the AMA computer student cannot be prosecuted for a crime that was not yet in place. Okay. Paano yung, nagtanong yung isang estudyante ko, paano ngayon, attorney? Meron ng batas ngayon may e-commerce law na ngayon, tapos may Cybercrime Prevention Act na ngayon. Pwede pa bang, kasuhan yung AMA computer student? Okay, what do you think is the answer to that question? Obviously, no. Remember, there are 3 characteristics of criminal law: territoriality, generality, and prospectivity. When we say prospectivity, meaning criminal laws shall apply in a prospective manner, meaning pasulong, hindi paurong. Meaning, hindi mo pwedeng i-apply yung criminal laws for past actions. Because at the time the actions were made, there is still no law. This is also in violation of an ex post facto law, which makes criminal an act before the passage of the law and which act was innocent when done. Okay? So, pag ang isang batas ay na-enact, for example, today, hindi mo ito pwedeng i-apply sa acts na ginawa mo kahapon. Because that criminal law should be prospective in application. Okay. Yan yung nullum crimen, nulla pena sine lege. What else? Isa pang example. You know the Katrina Halili case? Okay. The act of recording sexual acts. At the time that it was committed, there is still no Anti-Video Voyeurism Act. Wala pang batas prohibiting or making criminal an act, making criminal the act of recording or distributing sexual acts. In fact, the Anti-Video Voyeurism Act was enacted sometime on 2009. So, nung pumutok yung balitang yon, ang final ni Ma'am Katrina Halili is only for RA 9262, for emotional abuse. And the court ruled that there's no emotional abuse because the sexual act was consensual. So there could be no crime or there could be no sexual emotional abuse so as to cover RA 9262. So it was dismissed. Because of that, Congress enacted the Anti-Video Voyeurism Act in order to prosecute future acts of recording sexual intercourse with or without the consent of the parties. Okay, so dahil nung nangyari yung pag-record ni Hayden noon, wala pang Anti-Video Voyeurism Act, hindi pa siya pwedeng ma-prosecute under that law. Kasi it was enacted sometime on 2009 and the act was committed prior to the enactment of a law. So hindi pa pwede. Okay? Yun ang principle ng nullum crimen, nullum pena sine lege. There's no crime if there's no law punishing it. Okay, we go to the third element, which is the act is performed or the omission incurred by means of dolo or culpa. When we say dolo, we refer to intentional felonies, which means that the act is committed through malice and intent. May malice at may intent. Okay. When we say culpa, we pertain to culpable felonies, which are acts committed with lack of foresight, lack of skill, through negligence and imprudence. Kapag intentional felonies, may intent. Kapag culpable felonies, may negligence. Okay. Let's focus on intentional felonies. In order for you to prove that a felony, an act or omission, is intentional, there must be three things. Number one, freedom of action. Number two, criminal intent. And number three, intelligence. If you show these three elements, the act or omission would be considered an intentional felony. How are you going to disprove these elements? As to freedom of action, sasabihin mo lang na, I was forced, I was coerced, pinilit ako na gawin yung bagay na yon. Okay? Yun yun. Okay. As to intelligence, okay, sabihin lang na, baliw yan. Okay. Wala yan sa tamang katinoan nung ginawa niya yan. Meaning, the act is not voluntary. As to intent, you just prove good faith or mistake of fact. Okay. So let's focus on mistake of fact versus mistake in identity. So in order for us to understand the concept of Dolo for intentional felonies, we should digest the case of People of the Philippines versus Actus, which was decided on March 19, 1950. Parang chikahan lang. Sige. Chika-chika lang natin yung facts for mas madaling intindihin or mas madaling maalala. Gary and Arnel are roommates. They are working in a company. They have their own company quarters. So magka-roommate sila. Okay. One night, Gary was sleeping on the company quarters alone. Wala pa si Arnel. And tulog siya. Mahimbing yung tulog niya. Okay. At around 10 o'clock in the evening, nagising si Gary. Kasi may kumakatok. May kumakatok sa pintuan. Okay. Okay. Dahil may kumakatok sa pintuan, sabi ni Gary, "Who are you?" Okay, sino yan? Sino yan? 3 beses niyang tinanong kung sino yan. Wala pa ring sumasagot. Puro katok lang yung naririnig ni Gary. Okay. Despite asking who is that person, walang sumasagot. Okay. Binigyan ni Gary ng one last chance. Sabi niya, "Pag pumasok ka sa kwartong to, papatayin kita." Okay. Because to the mind of Gary, ang nasa isip ni Gary, intruder yung kumakatok. So sabi niya, "Pag binuksan mo yung pinto, papatayin kita." Okay. Wala pa rin sumasagot. Wala pa rin nagsasalita kung sino siya. Ganun pa rin, katok pa rin. Tapos biglang bumukas yung pintuan, nahulog yung isang chair na ginagamit ni Gary para isara yung pintuan. To Gary's mind, the intruder is forcefully entering the room. So anong ginawa ni Gary? Kinuha niya yung knife, tapos nung pumasok yung intruder, sinaksak niya. Sinaksak niya ng ilang beses. And when the intruder fell down on the floor, kinuha niya yung flashlight. Okay. Kasi sobrang dilim sa quarters nila. At that time, it was 1950s, wala pang masyadong kuryente, walang kuryente. Kinuha niya yung flashlight, nung inilawan niya, nakita niya, yung taong pala yun ay si Arnel. Arnel na roommate niya sa company quarters. Okay. Question. Is Gary criminally liable for the death of Arnel, who died upon the stab wounds that he inflicted on him? Okay. Liable ba siya? Is there an intentional felony? Okay, yes or no? According to the Supreme Court, in the case of People versus Actus, Gary would not be liable for the death of Arnel. Why? Because there was mistake of fact. And therefore, there is no intent or dolo. There is no criminal intent. There was no malice. In fact, there was good faith on the part of Gary. According to the court, the act done would have been lawful had the facts been as accused believed them to be. Meaning, on the mind of Gary, based on the facts, there was an intruder. He gave several chances to the intruder in order to ascertain his identity. But the intruder did not answer, hence giving Gary the right to reasonably presume that he was indeed an intruder. He asked several times kung sino yan, sino yan. He gave a warning. Kung pumasok ka sa kwartong to, papatayin kita. Okay. On the mind of Gary, there was an intruder. And if that fact was true, the act would have been lawful defense of property or defense on his life. Okay? Second, that the intention of the accused in performing the act was lawful. The intent of Gary was to defend himself and to defend his home against any intrusion. And number three, that the mistake must be without fault or carelessness. In that case, the mistake of Gary was without fault or carelessness. Why? Because he committed all the acts. Okay? He gave all the chances. He asked the intruder who he was. Okay? He gave a warning and then nothing. Okay? Therefore, he has a right to rely on his intuition, on the facts which appeared to be on his face. Okay. So therefore, Gary was not liable for the death of Arnel because there was mistake of fact. There was no criminal intent. There was no dolo. Okay. Walang dolo. Okay. The ruling would be different if there was mistake in identity. Okay. Ang pinagkaiba ng mistake of identity at ng mistake of fact is that in mistake of fact, there's no criminal intent. Wala kang intensyon na mag-commit ng acts. Only that you committed the acts because the facts appeared in such a manner, okay, that there is mistake. Okay, there's mistake of facts. Okay. Pag mistake of identity, you have an intention to commit a crime against a person. Only that because of mistake of identity, it was directed to another person. Okay. I will be discussing that later on sa Article 4, yung mistake of fact versus mistake of identity. Okay. But anyway, those are the liabilities of Gary. Those are the liabilities of Gary. In order for you to understand this, I suggest you read the case of People versus Atchong and People versus Wanis. Just research them on the scrap or on Lawfil in the internet. Meron yan. You just read. Okay. For culpable felonies, yun yung reckless imprudence resulting to homicide, reckless imprudence resulting to physical injuries. Okay. When you don't exert the necessary diligence in performing a particular act and it causes damage or injury to another person. Okay, what else? None? Okay, I will just be making a separate video for mala inse versus mala prohibita. Okay, kasi medyo mahaba na ito, hindi nyo na ito may download. Okay, if you have questions, you can just contact